Welcome to Looking at Legal Stuff. Today we have 3 hearings in a case with a couple where Dad is motioning the court for a change in custody. He claims there are several reasons why he's asking for this change, including the fact that Mom was recently arrested for felonious assault after an incident between the two of them. He also states that there have been multiple reports to CPS about Mom and her household, but the main reason he gives for asking for a change in custody is because Mom is refusing to let him see his child and has been withholding her from him no matter when and how often he asks. What does Mom have to say about his accusations? Let's find out.
Case number 1407979 DP, Palmer versus Deans.
All right. First on my screen is Javante Deans. Mr. Deans, our defendant in this matter. Good morning. You're on mute. Should be a red microphone. There you go.
Good morning, sir. I'm sorry.
Good morning. And next on my screen is Jocelyn Palmer. Ms. Palmer, good morning to you.
Good morning.
I have received a motion relative to custody from Mr. Deans. Ms. Palmer, did you receive a copy of that?
No.
Mr. Deans, how did you go about serving pursuant to Michigan court rules, Ms. Palmer with a copy of the motion?
By mail, sir.
Okay. Do you have her correct address?
Yes, sir. With the amount of documents that I'm presenting in this case, I had to use a yellow envelope. So when I sent it off, I only put 2 postage stamps on it. So they sent it back. So I had to put another one on and send it back off. So it might have showed up. It's guaranteed in her mailbox for sure. I don't know if she checked it, but I mailed it off earlier this week when they sent it back.
Okay. Well, let me explain what the court rules require. And this is found at Michigan Court Rule 2.119. The court rules say that you have to give notice and what's called serve a person a copy of your motion. If you're doing it by mail, they have to receive it, or not receive it, you have to mail it 9 days before the hearing. If you're going to have it hand delivered to the person, it has to be done 7 days before the hearing.
Mhm.
So if you got it back in the mail and didn't put the correct postage on until this week, that would not be enough time for me to hear this motion today. You would have to reschedule it and serve her correctly, meaning you'd have to put the correct postage on it at least 9 days before in the mail, and or hand deliver it through a process server or somebody like that at least 7 days before the motion. You pretty clear on the directions for that?
I am clear on the directions for that. It was just a mistake on my end on the postage stamps, I guess. I don't know how she found out about the court date if she hasn't received the paperwork.
I received the text messages let me know I had a Zoom meeting today. I received it actually day before yesterday. So I just showed up because it said what time to show up.
Did you happen to check your mail?
I didn't see it in my mail. I didn't check my mail yesterday. Before yesterday, I didn't check my mail, no. But I checked it earlier that week, but no, I didn't check it the day
But
before.
it really doesn't matter if she did. See, the problem is this, Mr. Dean, is if I were to do anything relative to your case and service wasn't proper, then it just gets undone and then we start back over. And I don't want to put you through that exercise, and I don't want to put Miss Palmer through that exercise. So the best way to do this is to reschedule this. You can go to the 5th floor Legal Assistance Center. They'll help you do that. Reschedule it make sure it's mailed to Miss Palmer at least 9 days before. And we will reconvene, or you can serve her by hand 7 days before. One of the
I'll just mail it off. I don't get to see her in person.
Okay, then probably the mail would be the best bet, but just get it there in plenty of time. And if it's a lot of paperwork, and I would go down to the post office and have them weigh it, make sure you get the correct stuff on it. You don't have to send it certified, but if you do that and you have a receipt from the post office about that you mailed it, then that's if it's 9 days before, then you're good to go. Okay, that's what I would do. That makes the most sense in this. But you can go to the 5th floor legal assistance center, and they'll help you renotice this. Okay.
Okay, so if one party doesn't receive the paperwork, then the process can't go on correctly.
No, that's not true. The process can go on. It's just if the person was served properly and just either chose not to receive it, didn't open their door for a process server, left it sitting in the mailbox for 9 days, whatever. As long as it was sent to her last known address at least 9 days before, then the burden becomes on her to get it. And like I said, the best thing to do is not to guess, is to go to the post office. You take an envelope there and you have them weigh it, and they will tell you the exact proper postage to put on it, and then you got no worries. Okay?
Right.
Everybody makes a mistake once in a while.
Right.
I mean,
And if I can,
I'm sorry?
I do have a question.
What can I do for you?
You say that this motion is for custody, as in if you're trying to get custody of the child?
Well, that's what it's captioned.
Oh, okay. I just was confirming.
I don't know what I've read it, but people sometimes caption things different than the way it really reads. So I'll wait for you to get a copy of that, and then we'll chit chat about it when we come back again. Okay?
Okay, no worries.
Have a great holiday, both of you, and we're adjourned. You can sign off.
And that is case number 1407979 DP Palmer versus Deans.
All right. Good morning, everybody. Ms. Palmer, or Mr. Deans, I should say, first on my screen. Mr. Deans, good morning.
Good morning, sir.
And Ms. Palmer is next on my screen. Ms. Palmer, good morning.
Good morning.
I think we adjourned this couple of weeks to make sure we're all on the same page. So I take it that's been done. You've gotten copies of all of this, Ms. Palmer?
Yeah, I got a copy, but it don't give me an option to. But maybe that's just me being slow. Yeah, it just gave me a basically the paper of what he's wanting. That's it.
Yeah, they have forms for that as far as a response to do that, and you can always file a response. That's up to you. But let me start with you, Mr. Deans. You're representing yourself in this matter, which everybody has a Sixth Amendment right to do in my courtroom. I have no problem with it, as long as they can do so without getting themselves into problems. How do you think you're doing so far, Mr. Deans, representing yourself?
We barely even began to start, honestly.
Well, let me just tell you where I'm going to. You've already broken the law. You've attached a Child Protective Service report to your motion, which is an illegal distribution of a CPS report. And I need an order from you striking that and sealing it in the file. because those are not made part of public record. And this is only step one. And this is what causes me concern for people. Because now, is there a police officer waiting by your door? No. Okay. It's a violation of the statute, but it's just somewhat of an indication that, look, attorneys have a tough time with this stuff. Okay. And from here on in, it's only going to get more complicated. And I don't want to see either one of you running into problems, not knowing that you can respond to motions, not knowing that you can attach CPS reports. So I strongly suggest that both of you consider hiring attorneys or coming up with their own agree. Hang on. I always give people a chance to talk, and let me finish. I hope both of you consider hiring attorneys because from heretofore, it's probably going to get more complicated. But I've read your motion, Mr. Deans. Is there anything you want me to know that's not in your motion before I hear from Ms. Palmer?
Honestly, I never even want to deal with the court. I've tried to settle things on the side with Ms. Palmer on the side multiple times. I just want my daughter in my life. I feel like I've been denied access to her through Ms. Palmer. As far as the records that I attach, I went to the fifth floor there, the Legal Assistance Center, and I also asked them about that. And they told me that that I could attach it. So
well, here's a little bit of advice for you. You never, first of all, they're not attorneys in the Legal Assistance Center, and you can't rely on any legal advice given from clerks, period. But as a more basic rule, you should never rely on any legal advice unless you paid for it. Okay? If you paid for that advice and some attorney told you you can attach a CPS report to a motion in a publicly filed document, then I would have your attorney sitting with me in some very difficult hot water. So always remember that if you don't pay them, then you don't have any right to rely on them, because CPS reports, I need an order from you sealing that as part of the record so that it can be segregated in your court file and can't be looked at by the public. You can attach things to my copy. That you can do, but unfortunately, you filed it with the court and you put it with that copy too. What a lot of attorneys do is they'll file it, refer to it, and then send it to me myself in an envelope marked confidential. That's the best way to do it. But I've read all this stuff. What's Ms. Palmer? The reason cited by Mr. Dean, so let me just try and boil it down. Custody was established in the judgment of paternity way back in 2015. And Ms. Palmer was granted the custody of the children or child. The reasons, because the court can't just stick my nose in people's business, okay? I don't do that, and the law does not allow me to do that. So before I can even stick my nose into your custodial arrangement, there has to be something called proper cause or change of circumstance. And that was set forth in the decision of Vodvarka versus Grassmeyer, 259 Michigan Appeal 499, a 2004 case. And that case said you need proper cause or change of circumstances since your last order, 2015, and these can't just be ordinary little stuff like your kids getting older or things like that. It has to be really of a magnitude to have a significant effect on a child's life. He lists a few things. First of all, he alleges that we should take another look at custody because Ms. Palmer was arrested and charged with a weapons offense, felonious assault, 2, child protective service involvement, and 3, keeping the party's daughter from him. So, I'll turn to you, Ms. Palmer. Tell me what's going on that we need to know about.
Regarding the children, I guess I could touch what you just said about the case. That case was placed from Mr. Dean's, and why I got arrested. It was a retaliation based off him not being able to get them for Christmas or one of those times, because he switched the date of when the incident actually happened, and my job caught it because I was in Lansing in training when he said it happened. That's why I was able to keep my job at the time, because the day he said it happened, I was in Lansing. But that's why I had that, because my record is clean. I've never been arrested. I don't have a criminal record. That was my first time ever been arrested because of me and him and I situation. But as far as
so just hang on. So just so I'm clear, you're saying that you were arrested, but you weren't charged or convicted of any criminal offense?
Correct. They dismissed it. Yes.
Okay. All right. So the next matter is there a pending child protective service investigation involving you and your children?
No, all my cases have been closed. Every case that I ever had, have quite a few. A couple of cases has been observance like from daycare. I had where they observed scratches on my daughter's back, but she has eczema, so they closed that because they seen that. Another, because my oldest was going through a temper tantrum. That's when I found out she had ADHD later on down the line. And neighbor called because they said that, I let her act out. And I did. She threw herself on the ground. She threw a temper tantrum. I let her throw a temper tantrum. That was another CPS came. They came to the house. Actually, the police came to the house that day. They said they see nothing wrong. That guy exit out. A situation that happened the third time was involving Dean's. He came to my house without permission and started an altercation with my boyfriend. Whatever he thought was safe or not safe, he came to my home with 2 men and caused issues that caused another CPS case. But that case actually opened, or was it the other one that opened? This case was actually closed. They closed that because the kids witnessed whatever they witnessed. So they closed that one out. And I think you have the CPS paperwork on all of that about firearm and all that and other things. Each kid had a different story on what they saw, they didn't see. But those 2 main cases was because of Dean's.
Okay. Are they still open? Done?
Cases, no.
Okay. The third thing that he mentioned is that you are keeping your daughter from, is that true?
That is correct. I took them when I was working a summer job. It happened this summer that just passed. I took Jemiah away parenting time because he's very inconsistent. He feel that he can get them when he wished to get them. He calls when he wants to get them. Like, instead of it being like a consistent thing, like every other weekend or agreeing on something. At first we agreed on that he would get them because my kids go to a year-round school, a charter school. I said, well, how about you get them on the days they have their breaks? If that works, because it's spaced out. It's not him getting them as much, because I figured that's how he like it anyways. And if he can get him to school back and forth. We tried to get him picking them up from school or getting him to school. That didn't work. He came up with excuse of his other kids that he had with his current girlfriend. So I never even mentioned that again to him.
What's the current order say? Is the current parenting time order?
No, I actually requested parenting time and never filed the paper. I never got around to it because I've been working overtime trying to pay off a lot of things that I have. So I've been busy working overtime and working and trying to get things situated for my home. So I haven't filed my paper. My paper is still in the envelope waiting to be filed for parenting time until I seen that filing for custody, but I can get why he think he deserves custody, but he does not get the kids enough his daughter enough to even try to get partial custody, no custody. I have to beg him to get them. And then when he does get them, a call the next day, and my boyfriend could witness. He'll call the next day like, oh, something came up, you got to get them, they got to go, emergency, or oh, this happened. But that's more than once that it has happened. So I just kind of like, you know what, I'm gonna push back and we're gonna do the parenting time. And
so it sounds like I have to at least send the parenting time issue to the front of the court, because
Yes.
you both need an order when Mr. Deans can have parenting time with his children specified, because it doesn't sound like you both are in a place, at least with each other, that allows you to pick up the phone and work with one another. So, Mr. Deans, I'll give you the last word.
Okay, sir. I just got a few things to say. I've never been inconsistent in my daughter's life. The only inconsistencies has come from when Miss Palmer has kept me away from my daughter. I've been sick fighting cancer in my life before. Miss Palmer has kept my child away from me. Then Miss Palmer has expressed to me before that she doesn't want my daughter, and she can come over my house. I beg for my daughter. I have messages begging for my daughter. Everything she's saying is a lie, basically saying I'm inconsistent. Her boyfriend and all this, she's only been with this man for a year. He's violent, in the report, that I wasn't supposed to turn in. You can see, when I came over there, my daughter's called me crying, feeling threatened. I came over there for their protection.
There's a problem here, and I think that obviously you both don't see the world the same way, unfortunately. Parents sometimes do, sometimes they don't. But let me tell you what I'm going to do about that. I just have one last question for each one of you. Are you currently working, Mr. Dean?
Yes.
Are you currently working, Ms. Palmer? Okay. So what I'm going to do is I'm going to really, it was what I call a three-legged motion for custody. Two out of those three legs are not in existence anymore. There's no pending or convicted criminal charge, and CPS has closed all their matters. The only thing left is the keeping his daughter from him, and I don't care for that one bit, but there's no order that tells you when you can pick her up, and there's no order when Miss Palmer's supposed to make them available. So we need that, absolutely need that. So I'm going to respectfully deny the motion on custody basis. However, I am going to grant the motion for this court to conduct an investigation and recommendation into parenting time, because I want an order that's going to govern everybody's conduct. Then Mr. Deans will have something to bring to court if Ms. Palmer doesn't do it. And then Ms. Palmer would have something to bring to court if Mr. Deans tries to step out of that order. Now, just so you both know, you both are humans, okay? And things come up, things happen. So you can have an order that has 500 different things in it, and somebody will think of 501. So you always got to be willing to work with one another. So I'm going to reopen parenting time and order that the front of the court conduct an investigation and make a recommendation to me as to what parenting time should be. The fees for that will be split between the parties. If the front of the court, if there's any question in your mind whether the front of the court has your correct information, your address, your phone number, your email, then you should go to 82 Ionia and straighten that out, because they don't forward mail. because those fees got to be paid first, and you can begin with that. I'll do the order of reference today, so probably sometime next week. And then they're going to make a recommendation to me, and it's going to contain all of the parenting time that's going to be conducted in this. And I would hope that the parents would follow that. If there's an objection to it, then I will schedule a trial, and we'll have a bunch of witnesses and a bunch of testimony, and people can subpoena everybody. And that's why I made that mention today, because those can be very complicated. And I don't want to see anybody getting into any more problems with this. So I will do that order today. And I need Mr. Deans to go to the Legal Assistance Center and prepare an order sealing the previously filed Child Protective Service report, so we don't run into any problems with that. And then you'll be hearing from the friend of the court probably in 10 days. So there's always a question, isn't there, Ms. Palmer?
I just want to make sure. So don't file my motion because
No.
I already had my parenting
No.
motion. Okay.
I'll take care of it.
Thank you.
I don't want
Excuse
to.
me.
Hang on a second. I know there's always a question.
No, it's not a question, sir.
Well,
So-
there's always a, just hang on. I'll get to you. I always give you the last word. It's your motion. So, no, don't file that, Ms. Palmer. I'm going to refer it to the front of the court. Now, Mr. Deans, what can I do for you?
I'm just trying to see my daughter. I haven't seen. I had to go to her school to see her. You know, pop in and see her. And sit in her class like once a week or something like that to see her. The only reason Miss Palmer doesn't have those charges is because I chose not to press the charges on her. I didn't want to.
And that's probably a good thing, because the mother of your children or your child, I don't think.
But
that
sometimes when you're a father and you're fighting for your kids, you have to do everything that you have to do in your power.
I'm not faulting you for doing anything. But what I would want to do, Ms. Palmer, is I want some parenting time before the friend of the court gets involved in this. So that's going to happen because I'll order it. So you can either agree to it or I'm going to order it.
Okay, you might have to order it because I'm not doing it.
All right. Then while this case is pending, you can prep this order too. Do you have a residence, Mr. Dean?
Yes.
Okay. And you have suitable accommodations for your child?
Yes, I had both of her kids. My child and her other child has beds and clothes and TV here, everything here.
Well, I can only deal with your
Yeah,
child.
I understand, but yeah, everything is here for them.
And not starting this week, starting next week. Parenting time from Friday at 6 to Sunday at 6. Until the friend of the court opens the investigation up. And then some time either on Christmas or on Christmas Eve, whichever is the holiday. Which holiday do you celebrate, Jocelyn?
I normally never ever have those days off, but luckily this time around I do. So he never really spent Christmas with him, so he can have Christmas if he want. I don't care. Time is what I want, so he can get whenever.
Okay. All right. So you can pick them up on Christmas, Mr.
Okay.
Dean.
Christmas. I'll pick my daughter up on Christmas. You said something about next Friday, correct?
That's when the every other weekend starts.
Every other weekend. So next
Friday at 6 to Sunday at 6.
Okay.
You pick the kids up, and Miss Palmer will pick them up from your place.
I get off. I work second shift. So I get off at 8. But if I can leave early and pick her up at 6 on Friday. That's fine with me.
Okay. then you can prep that order along with the order sealing it, and that will be the order until the front of the court completes their recommendation. You both are all set with me. Good luck to both of you. I hope you work this thing out. It would be a lot better if you did. Thank you.
Okay, now it's unmuted. Number 9 on our list, case number 1407979 DP Palmer versus Deans.
All right. I'm getting a lot of background noise from somebody. Mr. Deans, you're first on my list. Good morning to you.
Good morning, sir.
And Ms. Palmer, good morning to you. Can you hear me, Ms. Palmer?
Yes, good morning.
All right, good morning. We're unfortunately we're back yet again. Here, the motions have been set July 5, November 22nd, and now and 12/6, and now we're here today. I get the first part of this, Mr. Palmer, because we need to seal the CPS report that's in the file. So I will grant that part of your motion. And you need to prepare an order sealing the CPS report from the court file. The Legal Assistance Center on the 5th floor can show you how to do this. What I'm more puzzled about is the second motion you have. It says a motion for parenting time, and I think we already shoveled that walk, didn't we?
Yes, we had a conversation about that.
Well, we did more than that. We sent it to the front of the court, and they are hopefully in the middle of an investigation and recommendation, and they're going to meet with both of you to see if it can be resolved. And if it can't, then they're going to conduct a investigation and recommendation to me that the parties are free to accept or reject. And then if they reject it, if one party doesn't like it or both parties don't like it, then we got to have a whole trial on this. But I already set the wheel spinning on parenting time. What are you asking me to do today?
Honestly, it was a misunderstanding through, I don't know if you were familiar with Project Green, which is a grant funding project through FOC. I've been in contact with, okay, I've been in contact with them. It just was a misunderstanding.
Have you heard from the front of the court yet, both of you?
I've just received a letter yesterday from them. It's been a while. My only concern was, basically want to see my daughter more, having to wait, for FOC to get involved to see her. It's kind of frustrating. I appreciate you granting me the parenting time that you did. I did spend time with my daughter last weekend. I appreciate that. But I feel like I need to be in my daughter's life more. I need to see my daughter when I want to. There's no restrictions on my parenting. Hey, I'm sorry about that, sir. There's no restriction on my parenting. All my child support is caught up. Everything, nothing. The only one who says I can't see my child is the mother, and she has no say so on that.
Well, not quite accurate, but
by law, Michigan is a 50-50 state to my knowledge.
No.
I do pay child support.
Oh, you do, Mr. Deans,
Yes.
but I don't want you to get into trouble. People that start quoting the law to me usually don't end up very well. Because what I try and do is I will always over prepare motions. We are not a 50-50 state. I know there's talk of trying to get there someday. Obviously, both parents have to, if there's an order out there, both parents have to follow it. If there's not an order for it, then we have to get one. And that's what I'm in the process of trying to do. I can't do that on a Friday morning because the law says that I have to have an investigation that deals with more than just, this is what I want. I need to deal with all the best interest factors, and there's 12 of them. And I can't possibly do that on a Friday morning. That's why I sent it to the front of the court. Now, obviously, I would hope that at some point in time, you, Mr. Deans, and you, Ms. Palmer, get to a point in your lives and in the lives of your child that you can simply work it out between yourselves. But you two are not at that place right now. And I'm trying to help you with that regard. So you'll have plenty of opportunity at the front of the court to reach an agreement with Ms. Palmer. And then, but usually, and if you go in with somewhat of a negative, it's not going to happen attitude, I hope that it does. There's going to be somebody to help you do that, and hopefully between that person and the friend and Miss Palmer and you can reach some sort of accord and get to where you want to get to. But right now, you're not at that place, and I'm taking all the things the law allows me to do to get this thing moving forward for you. So I appreciate the fact that it does take a little while. It does. I apologize for that. But the this whole process is more than just coming in on a Friday. But I will grant the first part, and you can prepare an order sealing the CPS transcript, and then I can get you out of hot water on that issue. And I'll deny the parenting time because that issue right now is currently pending at the front of the court.
I do have a
What can I do for you, Ms.
Okay, so we do want parenting time. We both can agree on that, him and I. But I do have a question when it comes to. I did receive an email from the FOC, and it says something about we both have to pay $150. With the same form that you use, that you can get that waived, or is that impossible?
That's not impossible, but if both parties are working, I don't waive it.
Oh, okay, no worries. No, I can pay. I just was asking.
Both parties are working, then I don't waive those fees. So, but make sure you comply with that stuff because if they terminate this, we're back at square one. And they're going to meet with both of you first. That's their step one before they do any investigation, is they sit down with both of you and say, let's get busy. Let's come up with something we can all live with.
Mm-hmm.
So I hope you succeed in that regard. So thank you both very much. Have a happy holiday, and we're adjourned. Thank you.
Thank you.